Hello there. You have landed on the Disability Law Show. Thank you so much for tuning in again this week. John Scholes here, James Fireman, disability lawyer at disabilityrights.ca. Always reach out to James and his team. If it's just a question or conversation, even a consultation, that won't cost you anything. Just pick up a phone, 1-855-821-5900, and with the email to go along with, that is help@disabilityrights.ca. We'll have a main topic in our second segment like we always do. That's the general pattern of the show. This week it's going to be LTD benefits and addiction, what the insurance company won't tell you. We'll get to that, some phone calls, email questions. It's a full show as it always is, James, but you always tell us a little story off the top of the show. So what do you got going on this week, pal?
I want to talk to you about a client of mine, or a recent client of mine named William. And he was a pharmacist who had some significant mental health issues, panic attacks, depression, ADHD, and it got to a point where eventually he wasn't able to continue working. Now, thankfully, he had really good support from his doctors, from his therapists, and he was approved for long-term disability, and actually was approved for several years, well into what we call the any occupation phase. So the insurance company had agreed that not only was William disabled from his own occupation as a pharmacist, but after 2 years, he continued to be disabled from any occupation. The problem was that part of William's issue was communication. Part of the issue was dealing with other people. He had a lot of anxiety, and it would manifest in panic attacks when he was dealing, especially with a large group of people or people that he didn't know very well, people that he was unfamiliar with, or that he didn't trust in any particular way, like insurance companies. And so communicating with his insurance company was always something of a chore, but he did his best in order to make sure that he was complying with what the policy requires. You have to keep your insurance company up to date on what's going on. If they're emailing you and calling you, you have to do what you can to return those communications and make sure that you're providing them with the information that they need. Now, a lot of that information can be provided by your doctors through the clinical notes and records, tests, assessments, and so forth, but insurance companies, as you are on claim, also want to get updates from you directly. They want to know about what you're doing on a day-to-day basis, what your activities are like, what you're having difficulties with. And they'll have long conversations with you periodically. It will depend on your particular disability and on your case manager how frequently that's going to happen. But it will happen on a fairly regular interval, especially during the first couple of years of your disability claim. And so they're basically looking for reasons why they can justify putting you back to work, but you have to respond to them. And so the issue with William was, at a certain point in time when he was at a low point in his recovery, when things actually had gone backwards for him, he was having more difficulty, in particular, communicating with his insurance company. And so they had called a couple times and he hadn't returned their calls, and they'd sent him an email. Now, he had responded to the email and he'd provided some detail. It wasn't quite as thorough as you might normally expect, but he wasn't non-responsive. He wasn't ducking them. He wasn't ghosting them, as the kids say these days. He was actually providing them with some information, and even said, you know what, if you want to give me a call later on, we can arrange it. They tried, they weren't able to do it. Eventually what happened is the insurer simply used this as a justification for terminating William's benefits. They said he was not responsive, he wasn't providing them with sufficient information, and therefore he was in breach of the policy. They weren't saying that he wasn't disabled anymore. They were saying that he had breached the policy because he wasn't responding frequently enough. Now, there is a difference between imperfect compliance and non-compliance, and Williams was certainly in the former category. It wasn't everything that the insurer might reasonably expect, but it wasn't that he was not complying either. He was giving them what he was able to do in the circumstances, and certainly the medical records supported that it was a particularly difficult time for him. So that he actually had tried to appeal before he saw our show and gave us a call. When he did, we started litigation, and guess what? We get to mediation, and the insurance company is represented by lawyers who have a far better understanding of what the law is going to say about this if it ever was in front of a judge than the case managers do. And so when we got to mediation, Williams' benefits were paid not only up to the date of the mediation, so everything that they owed him in the past up to the date of mediation, but for 6 years into the future, which is considerably more than you might otherwise expect given what the medicals had said. And I'm quite sure the reason why they did that is because they understood that if this case ever got in front of a judge was going to look at what they did and say, you were being opportunistic there. You were preying on someone who was vulnerable, someone who you knew had issues with communication, who found it difficult, and who was still doing their best to comply with the obligations under the policy. You can't use that as a tool to try and terminate benefits. That's bad faith. And when you act in bad faith, if a judge finds that, there's going to be punitive damages, which means that the insurance company would have been on the hook not just for the benefits, but for paying an additional amount, often quite significant, on top of those benefits. So my guess is the insurance company understood that and paid far further into the future than they normally would have in order to avoid the case going any further.
That has a good ending. Let me ask you this part, James. You mentioned part of the communication is going to be between the actual person who's off on disability and the insurer. It could be phone calls or emails. We've talked about in the past on the show that the language you use, being not a lawyer, being just a person who's on disability, especially with some mental issues, do you have to be careful with the language with the insurance company? I mean, the classic one is always like, how are you doing today? Oh, I'm great. Okay, that can be taken the wrong way. It's not colloquial speech, but, oh, he said he's great. Why is he on disability? You know what I mean?
It's a really good point, John, and that is certainly something that everyone should be aware of. Now, I don't suggest that anybody should treat their insurance company or the case manager rudely in any way. You should be pleasant. They're people too, and it's not necessarily the case that they have an agenda that is evil, but keep in mind they work for an insurance company whose objective is to find a way to get you off of benefits. And so ultimately, at the end of the day, that's what their job is. Doesn't mean you have to be unpleasant, but you have to be aware of what the dynamic is in your relationship with the insurance company and with the person that works for the insurance company, the case manager that you're dealing with on a day-to-day basis. Understand what their role is and let that guide how you communicate with them. Be polite, but be careful. Measure what your words are. Don't feel like you have to respond immediately to every question. Pause. Think about what you want to say and be careful. Now, you have to be honest. I'm in no way, shape, or form suggesting you should in any way be dishonest. But you want to make sure that what you are saying is in fact what is happening and accurately reflects your situation. You don't want to be a hero, you don't want to minimize anything, nor do you want to exaggerate. If there are activities that you're able to do, there's no reason not to acknowledge them. If your doctor has said you should go swimming every day at the local pool and you're doing that, then you should acknowledge that. And there's a possibility that they could have even gotten surveillance that shows that. So you want to make sure that you are being 100% honest when you are talking to your insurance company, but be measured. Don't say anything more than you need to. Whatever the question is, just answer that question. Right. Don't feel the need to provide any additional context or information unless and until they specifically ask you for that.
If you're wondering if and when you should reach out to James, there's also a website for that, pocketdisabilitylawyer.ca. Bunch of drop-down questions, takes a couple minutes to go through it, and it'll basically say, yeah, you know what, you're okay, or you should probably, if you want to, reach out to James maybe for a free consultation or a chat anyway. Again, pocketdisabilitylawyer.ca. Phone calls from our radio show. First one for this half hour is coming up right now. Let's listen in.
I've been on long-term disability for a few years now. My psychiatrist mentioned that some light travel to see family would significantly help me improve, but I'm worried about notifying the insurance company about this. Should I inform them about travel plans, or will they see this as I'm ready to work and cut me off?
It's a reasonable worry. Yeah,
no, it's a great question. And so I think the first step is understanding how travel works, what your restrictions are when you're on a disability, when you're getting disability benefits. So each disability policy is a little bit different in this regard. When we're talking on this show, we're often talking about what we're referring to as this mythical standard disability policy. Now, for the most part, for the substantive portions of the policy, it's almost all identical policy to policy, but there are some issues where you do see variance, and this is one of them, travel restrictions. So oftentimes what you will see is an entitlement for you to travel within your area, which is typically going to be Canada, for a limited amount of time without needing approval. So sometimes I've seen as little as 2 weeks, 14 days. I've seen 30 days, I've seen 6 months. I've seen policies that have no travel restrictions at all. Whatever it is, you want to make sure that you're familiar with it first before you decide how you're going to deal with it. So let's say you have a 30-day travel restriction and your doctor, as this caller's doctor has done, says you should go do some traveling for a week or so, get some sun perhaps, that'll put you in a better frame of mind. And you say, okay, I want to do this. Well, in that circumstance, what you want to do is, with your doctor's advice, you want to get that in writing, and then you want to make sure that you have any treatment plan that is necessary available to you while you're traveling. So if you are taking medication, you want to make sure that you have enough medication for while you're away. That is common sense, of course. But if you are getting regular therapy, whether in this case we're talking about a psychiatrist, so I assume that there is perhaps some psychotherapy sessions that they're getting with a psychotherapist or perhaps a counselor, you want to make sure that there isn't a break in that treatment. And so if necessary, you have a treatment right before and then right after, or perhaps you can even do it virtually if you're away for a little bit longer. Whatever it is, you want to make sure that you've addressed the treatment so that when you present this to the insurance company, there is no argument that you haven't continued to get the necessary treatment that's required under the policy. Once you have all of that in order, as long as you're within the budgeted time that you're allowed to travel without permission, I would suggest in that scenario, once you have all that aligned, I would go. I wouldn't necessarily tell the insurance company. If they are asking you, if they're saying, are you going to be available for an assessment here or phone call here, yes, tell them that you're going to be away. That's perfectly fine. But if they're not asking, you're under no obligation to tell them in advance that you're about to go. And I wouldn't do it as long as you're within the travel restrictions. And the reason I wouldn't do it is because you don't want to give them an opportunity to interfere with your travel plans intentionally. And I've seen that happen. When people have a trip planned and the insurance company says, oh, well, we're going to have an assessment for you on that day, so you're not going to be able to go. Essentially, they're trying to make sure that they set up a scenario where you're going to be in non-compliance with the policy. So I would, after the fact, tell them that you went on this trip. It was with the approval of your doctor. It's going to be in the clinical notes and records of the psychiatrist. You maintained your treatment the entire time you were there. There's nothing the insurer can do about it. You haven't breached the policy. There is no real argument against what you've done. Now, if you're planning to travel beyond what the limitations are, you have to get permission from your insurer in advance. I would go through the same steps. I would get the approval from your doctor in writing first. I would make sure that you have continuing treatment available to you that you can present to your insurer. And then I would go to the insurer with a note from your psychiatrist saying, this is part of your treatment, this is recommended, and you're going to make sure that you're not having any gaps in any portion of your treatment while you're away, and then ask your insurer for permission for you to be able to go for that period of time. That's the way that I would approach it. I would not ask them, again, I would not ask them in advance if you're within that travel budget and you've taken those steps that I've just recommended.
Well answered, but it's time for a short break. On the return, it'll be the main topic, LTD and addiction, what your insurance company will not tell you. That is on the other side, so stay with us as we continue more of the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Disability Law Show. We're back at it. James Fireman, reachable anytime, 1-855-821-5900. Email help@disabilityrights.ca. Love the main topic this week. It is LTD benefits and addiction, what your insurance company won't tell you. Number one, addiction is recognized as a disability, James, and you may qualify for LTD benefits if your condition prevents you from working, right?
Yeah, this is a topic that we've discussed many, many times on both our radio shows and the TV show. Addiction is a difficult issue when it comes to discussing disability benefits. There's a stigma to addiction that doesn't exist for physical disabilities and exists, but to a lesser extent, for other mental health disabilities. People that have addiction issues are often afraid or embarrassed about acknowledging that they have an issue that is functionally limiting them from being able to work. And so, the first step is acknowledging that there's an issue there and seeking treatment. Until you do that, there's nothing that I as a lawyer can do for you, and there's nothing really anyone else is going to be able to help with. That's an easy thing for me to say. It's a much more difficult thing to actually do if you're in that scenario. But the reality is what we see is people with addiction often don't even start the application process. And that is step number one. If you are dealing with an addiction issue that is preventing you from being able to function in your occupation, talk to your doctors. And if your doctors agree that you shouldn't be working, apply for the disability benefits. I know that's easy for me to say, but it is a necessary step if you're going to be able to get the treatment that you need in order to recover. So please, please do that. If you are disabled from working because of that, if you have the support of your doctors that you're not able to work because of addiction issues, then you're entitled to disability benefits. It's as simple as that.
Second point ties in nicely with what you just said, James. That is, insurance companies often deny claims for addiction, much like mental health claims. You just mentioned that.
Yeah, it's not as bad as it once was. When I started out, mental health claims and addiction claims were treated as though they were not valid in any way, shape, or form. There was the rare situation where you would see them approved, but insurance companies would routinely deny claims for addiction and for most mental health claims as well, too. Now, the world has changed. Over the last 15 or 20 years, people have a much better understanding of mental health issues and, in particular, of addiction issues. So it is not the case that it's automatically going to be a no if you have a disability for mental health or for addiction issues, that your insurance company is automatically going to decline your application. But it is also true that it is more difficult if you have addiction issues. It is less likely that you will be approved, and you need to be aware of that. Now, that's the bad news. The good news is just because your insurance company may not approve your claim doesn't mean that you're not actually entitled. And if you are entitled, if your doctors, your treatment providers have told you that you have a disability, you have addiction issues that are preventing you from being able to work, then you are entitled to benefits under the policy, whether your insurance company agrees or not. And if they don't agree, that's exactly why we're here.
LTD and benefits, what your insurance company won't tell you, an addiction. Third point is this: if your claim is refused, you don't have to accept it. You're going to reach out to James, take legal action. Yeah?
Yeah, and so addiction is really a big problem across Canada, and it's not just an issue about your socioeconomic status. For those of us that live in Toronto, we know this pretty well. We, had a few years of a mayor that had a very public issue with addiction problems. So this isn't something where we're just talking about people who are impoverished. This affects people of all socioeconomic classes. Wherever you are, you do see addiction issues. So the good news is, if your claim has been denied, you've already done the hardest part. If your claim's been denied, it means you acknowledge that you have an issue and you've actually gone through the application process. Again, as long as your doctors are telling you that your addiction issue is legitimately preventing you from being able to do your own occupation, your claim is going to be valid, whether your insurer sees that or not. And if they don't, you give us a call. There's a free consultation, and as long as you have the support of your doctors, there's going to be a valid claim there, and we can look at how to start litigation in order to get the benefits that you're entitled to.
After that, which is now, we're going to take a short break, bounce back with some email and other questions, so stick with us. In the meantime, Disability Law Show continues. Stand by.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, back with a few more minutes of the Disability Law Show. Beyond that, always reach out to James and his team. Consultations won't cost you a thing. Phone calls and information and questions, all the same. 1-855-821-5900. Help at disabilityrights.ca. That is the email address which Valentina has used. Here's the email. James says, I went on short-term medical leave almost a year ago. At the time, I was regularly seeing my family doctor and a psychotherapist. I was dealing with anxiety and panic attacks after losing a close friend and working in a toxic environment. After a few months, it became clear I needed more time to heal. Even though my doctor supported me, my LTD claim was denied. They said my condition was situational. What can I do?
Well, let's talk about that. Situational. What are we talking about there? So when you apply for disability benefits, your insurance company is going to look at your condition and see whether it is something that impacts your condition generally or situationally. And most often we see this when we're talking about anxiety-based disorders. So a situational condition is a condition that only exists in one specific environment. Typically we're talking about your employment, your occupation. And so if you are in a toxic work environment, which Valentina is describing as at least part of the issue here, and if your anxiety only exists when you're in that environment, then that is a situational disability. In other words, if you remove Valentina from that environment, if she were to get employment from a different employer but the same occupation, she would be able to work because she's not in that environment. It's no longer situational. And if that's the case, the issue is with your employer. It's not a disability claim, it's an employment claim, and you call Lior and his team. But this is not what we're talking about here. This is not strictly a situational issue. I can tell that right away because Valentina's already told us, yes, there's a toxic work environment, but it also happened after she lost a close friend. That's got nothing to do with the toxic work environment. And I would be shocked if the loss of a close friend wasn't a significant issue in her anxiety and panic attacks. I could be wrong, but if a doctor says that her anxiety and panic attack is related to the loss of a friend, and more importantly, that she's got a generalized condition that's going to exist, whether she's with her employer or anywhere else, then it is not situational. It is a general condition and she's entitled to benefits. Now, there's a particular phrase here that comes up and leads to this kind of decision a lot, and that's toxic environment or toxic work environment. Whenever I see that phrase referenced in the medical records anywhere, or perhaps even in a conversation between the potential client and the insurance company, whenever that language is used to describe a work situation, I know 99% of the time the insurance company is going to deny the claim. They're going to say it's a situational issue, this is a claim against your employer, this has got nothing to do with us. But as I've just explained, that is not true. It doesn't even matter whether your disability was caused entirely by a toxic work environment. Even if Valentina had not lost a close friend, it does not necessarily mean that she doesn't have a disability claim. Now, she would still have to be able to show that her disability has gotten to the point where it is generalized, where she is no longer able to do her occupation, whether she's in the toxic environment of her employer or any other employer for that matter. If she can show that, if she's got support from her doctors, and that certainly does happen at times, then she would be entitled to her disability benefits. But as soon as I see toxic work environment, I know the insurer is going to stop their analysis right at that point because it's easy. They can say, okay, well, toxic work environment, we don't have to pay. But that is not an appropriate analysis. You have to go much deeper than that. So if your insurance company is saying, okay, it's toxic work environment, situational, you're not entitled to benefits, do not stop there. Give us a call because more often than not, there is something that we can do about it.
MyDisabilityQuestions.com, a free website for you to ask questions, similar to email. From it for the show, last few minutes here, Ian says, I've been receiving LTD benefits for almost 3 years due to chronic pain after a back injury. After being told to apply for CPP Disability by my insurer, I was unfortunately denied. What does this mean for continuing LTD payments?
let's talk about CPP disability. It's been a while since we've done it on the show. So CPP Disability is a federally run program. It's part of your Canada pension plan. So if you've been paying into CPP, if you get that deduction off your paycheck every week or every 2 weeks for CPP, then you're entitled, if you become disabled, to apply for CPP disability benefits. You don't have to wait until you're in your 60s to do it either. Now, the test to be entitled for a CPP disability is different than what you would find under a typical long-term disability policy. For a CPP disability, it requires a severe and prolonged disability. So in my view, and this is consistent with my colleagues as well, and frankly for most people on the defense, the test for CPP disability is more onerous. It's a more difficult test than the LTD disability test. So even if you're entitled to LTD disability, it does not automatically in any way, shape, or form mean that you're going to get CPP disability. You may apply, and much like Ian here, you may be denied by CPP. That does not mean that your LTD is entitled to cut off your disability benefits. Again, it is in substance a different and more difficult test than LTD. And so that you have been denied for CPP disability, again, doesn't entitle your insurer to do anything. Now, having said that, why would you apply for CPP disability? Because what you need to understand is if you're approved for CPP disability, it usually does not mean that you're going to get any more money at the end of the day, because almost all disability policies have a provision that says if you are approved for CPP disability and you get, let's say, $1,500 a month, I think the maximum now is about $1,700 a month, what happens is your insurance company gets an offset to the benefits that they're required to pay you. So let's say you're entitled to get $4,000 a month and you get approved for CPP disability at $1,500. Well, now instead of paying you $4,000 a month, your LTD insurer deducts that $1,500 and only pays you $25. And so you may be wondering, well, if that's the case, if I'm not getting any more money in my pocket, why bother doing it? It's a good question. The reason you should bother doing it is if you look further in the policy, most disability policies will also have a provision that says if you don't apply for CPP disability, your insurance company can assume that you did, assume that you would have been approved, and then estimate what that approval would have been and take a deduction for that. So if you don't apply, you're not getting anything, and you're in fact going to get a reduction in your benefits down the road. So you might as well apply, see if you get approved. If you do, you're not in any worse situation, and because it's a more difficult test, it really becomes more difficult for your insurance company to cut off your benefits. But if you are denied, at the very least, you've got that protection against your insurance company saying, okay, well, we're going to estimate what you would have gotten if you'd applied, because you have applied. You applied and you got denied, unfortunately. But you're not in any worse situation. Now, does that mean that every insurance company is going to acknowledge that's a more difficult test? No, some of them will try and use that as a justification for terminating benefits, but I've never really seen an insurance company say that that's the only reason they're doing it. That would obviously be incorrect. That might lead them down the road to try and gather more information in support of it, but it's not a reason not to apply. The downsides to not applying far outweigh the benefits to applying. So if you're asked by your insurance company to apply for CPP disability benefits, you should absolutely do it. If you have any concern about it whatsoever, though, give us a call. It's a free consultation. We have lots of information on our website as well, dealing with how CPP disability interacts with long-term disability claims. So that's there for you. It's free of charge. By all means, go on our website, get that information, give us a call, free consultation.
And that'll pretty much wrap it up for the show this week. You want to reach out to James, as you should. Consultations won't cost you anything. Just pick up a phone, use the number, send the email along with it, 1-855-821-5900, help@disabilityrights.ca, and pocketdisabilitylawyer.ca to find out if you even need that phone call. It's free and anonymous as well. And we'll catch you next time on the Disability Law Show. Thank you so much for tuning in.